your lordship to grant the application. Thank you, my lord.
Yes, the defendant's motion to regularize, that's the reply. I believe should be reply on points of law.
Yes, my noble lord. Yes, my noble lord.
So,
Yes, my noble lord.
yeah, Barnabas, where's the application? Okay, dated 15 January, 24th January.
As the court places.
So others are granted as free.
As the court places. My noble lord, the defendant's final written address was filed on November 21st, 2024. November 21st, 2024.
Yes.
Why the reply on point of law was filed on 13th January 2025. Reply on point of law was filed 13th January 2025.
Yes, I'm doing proper to do.
My noble lord,
Yes.
the two addresses represent the totality of the defendant final written addresses in this suit. And we urge your lordship to dismiss the suit.
Yes, counsel.
We are most grateful, my lord. No adoption. Thank you,
All
my
right.
lord.
Yes, Zoko.
Yes,
It's Zoko. Yes,
Zoko. Yes, Zoko. Yes, ma'am.
Yes.
As the claimant filed its final address on the 10th day of December 2024. Dated and filed the 10th day of December 2024.
Tenth day of December. Yes, counsel.
10th day of December 2024.
Yes, I've confirmed that. Yes.
Yes, my lord. Okay, my lord. Yes, we adopt the final address as our oral and legal argument in support of our case. We adopt the written address as our oral and legal argument in support of the claimant's case. And we
Yes.
We urge my noble Lord to grant the reliefs sought therein. We are most grateful. No adumbration, my Lord.
All right. Can you check your diaries, counsel, for 10th of April?
As the court pleases.
It's
Is
convenient,
that
Your Lordship.
to both counsel?
As the court pleases.
Convenient. 10th of April is convenient.
The case is further adjourned to 10th day of April 2025 for judgment.
As the court pleases.
We are most
All
grateful,
right.
Your Lordship. We are most grateful.
Thank you, my Lord. Thank you.
You're welcome. So I think we are done with this. We can now switch to Sokoto. So give me the first file for ruling for Sokoto. What's the name of the officer in Sokoto? Abbas? Sokoto, are you connected? Can you call him, please? So that
yes, madam.
okay, right. So can you call the first case there?
Yes, madam. NICN/SK/04/05/2024 between Comrade Abubakar Abdullahi, Makama in bracket, and 9 others, versus Nigerian Union of Local Government Employees, Zamfara State Chapter, and 9 others.
Do we have any of the parties in court there? Because I know they usually make themselves available in court in Sokoto. None of them?
None of them, madam.
All right.
Parties not present, but the defendants are being represented.
Okay. Represented by
Musa Rabodawa Labaran and Eyebu Balarabe Isa for the defendants, my lord.
Done. Not the appearance now. So the parties are absent. Sorry, I didn't get you right, counsel. So I'll check the appearance now. We'll start with the claimant. Yes, claimant, counsel, please.
Claimant. Yes, my lord. U.S. Abakar for the claimant.
Counsel, what's the name again? I can't hear because usually the network there is it's an issue. So you may have to, you end up spelling the names, I wouldn't mind.
U.S. Abubakar.
Okay, U.S. Abubakar.
Yes, my lord.
For the claimants?
Yes, for the claimant, my lord.
All right, defendant counsel, please.
With utmost respect and humility to my noble lord. MRD for initials. Labaran. MRD.
D, yes.
Labaran. Yes, my lord.
All right.
DB and DB Isa for the defendants.
With
DB Isa for the rest.
That's Dayabu Balarabe. Yes.
As the court pleases, my lord. That's right.
Yes, counsel.
For the defendants.
Yes, so the matter is for
Objectors.
ruling.
The matter comes up today for ruling subject to the utmost convenience of the Honorable Court.
So I shall proceed to deliver the ruling.
As the court pleases.
The claimants initiated this action against the defendants by means of an originating summons application dated on 15 August 2024 and seeking for the interpretation and determination of the following question: whether the action of defendants by presenting themselves and be re-elected for third term in office as State Executive Council of the Nigeria Union of Local Government Employees and Zamfara State Chapter does not violate the provision of Rule 21(4)(a) of Constitution, Nigerian Union of Local Government Employees 2016 as amended. Claimants have further sought for relief 1 to 10 as contained in the body of this ruling. The originating summons is accompanied by the claimant's affidavit in support of 5 paragraphs and deposed to by one Mariam Hassan, litigation secretary in the law firm of Hamza Liman and Co., with a written address filed in support of same. Defendants have, in their response to the claimant's application, filed a memo of appearance alongside a notice of preliminary objection on 26th of August 2024. Meanwhile, the claimant had filed a notice of discontinuance of suit against the 4th, 5th, 7th, and 9th claimants, which was not objected to by the defendants. This court set the matter down for hearing of the notice of preliminary objection on 10th of December 2024. The claimants who had knowledge of the hearing date were not present in court, as well as their counsel. Since the defendant's counsel was present and prepared to proceed with the application, same was taken by the court. It is, however, pertinent to mention here that the claimants did not also file any reply to defendant's NPO. Defendant's notice of preliminary objection is dated 23rd August 2024 and filed 26th August 2024. The application is predicated upon 13 grounds as contained in the application, with 6 paragraphs affidavit deposed to by one Comrade Nuhu Baba Ahmed, an employee of Nolgi and serving secretary of Zamfara State Branch. The exhibits are next to affidavit in support of MPO are exhibits A, B, C, D, S5, S6, and S7. In the written address in support of application, dated 23rd August 2024, defendants' counsel formulated the following 2 issues for determination: whether claimants have no standing or legal capacity to initiate and maintain the action in the light of non-compliance with the mandatory provision of Rule 5A, B, and C, and Rule 511 of the Constitution, Nigerian Union of Local Government Employees 2016. 2, whether originating process is incompetent in the face of the infringement of the rules of court. Submission of defendants' counsel is that the originating process of claimants served on them is grossly incompetent, that the claimants, with the exception of the 1st and 6th claimants, are members of Nolge who have subscribed to its constitution and therefore bound by its constitution, referring to Rule 5, Sub 5A and B of Constitution of Nolge 2016 as amended. Defendants submitted that claimants are stopped from resorting to any dispute or conflict resolution, including litigation, without first exhausting the laid down dispute resolution mechanism provided in the Union Constitution. They further relied on Rule 5, Sub 11 and 2, Sub 11, Rule 5, Sub 2, 3, and 11 of the Union Constitution, and submitted that the claimants are required to firstly submit their request for interpretation to the Union before resorting to any other forum, including the courts, if the need arises for interpretation. The parties are bound by the terms and conditions they willingly subscribe to in the light of the express unambiguous provisions of the contract of the parties. In aid of all the arguments, defendants relied on Egwami Vense and Amgi Zemwe, citations provided. According to counsel, or according to defendants, the claimants have not abided by the provisions of the Constitution of the Union. The claimants lack the prerequisite capacity to initiate and maintain the action, and the court also deprived of the power to adjudicate on same. They then urged the court to resolve the first issue in the positive and dismiss the claimant's action with substantial cause. On the second issue, defendants submitted that claimants have not complied with the mandatory rules of court in initiating this action, thus depriving court of jurisdiction to adjudicate on same. That the first claimant at the time of filing the action had no standard, having ceased to be a member of NOLGE, since he has exhausted his years of service as an employee of any local government, which entitle him to membership of the union, relying on Rule 3, Sub 1A to K. That the first claimant has been served with a letter by the union communicating his seizure to be a member of NOLGE by reason of retirement. It is a further submission of defendants that the claimant's originating process bears different suit numbers with the affidavit, and the required copies of processes were not served on the defendants. Furthermore, that the defendants were served with unauthenticated photocopies of originating process in breach of Order 3, Rule 17 and 19 of the rules of this court. That claimants are further in breach of Order 3, Rule 1 and 2 of the same rule. Defendants again submitted that first defendant is a non-juristic person, and the name by which it was sued by claimant is not a name recognized under Rule 2, Sub 4 of NOLGE 2016. Decision of the court. Counsel, I hope you are still with me. Do I have Ibrahim Rua online, please?
We are, my lord. We are listening.
All right, thank you. Now the decision of the court. It is pertinent to mention here again that the claimants failed to respond to the preliminary application of the defendants. It is a settled principle of law that where a respondent, as in the instant case, fails to respond to a notice of preliminary objection, he is deemed to have admitted all the issues raised and canvassed in the preliminary objection. See Goji versus Ewete, and equally Kaki versus PDP. The citations are all provided. The claimants in having failed to reply to defendants' notice of preliminary objection duly filed and served on them, and by the above authorities cited, claimants are deemed to have admitted the contents and facts in the preliminary objection served on them, and I so hold. Again, the defendants have challenged the claimant's suit on the ground that it is premature. The claimants having failed to firstly submit their request for interpretation to the union before resorting to any other forum, including the court. In paragraph sub 1 of the support of application that the claimants are members of the NOLGE and bound by the rules 5, sub 5 A, B, and C, and 11, which requires them to exhaust the laid down procedure for resolving conflicts and or disputes. See Exhibit D, annexed to affidavit in support of notice of preliminary objection. Now, Rule 5, sub 11, and 5 A, B, and C of Nigeria Union of Local Government Employees, NOLGE, amended Constitution 2016, provides thus. In the event that any question arising as to the interpretation of any rule of this Constitution, the issue shall be referred to the National Executive Council for final determination. 5. No new rules of Constitution shall be made or any rules altered, amended, or rescinded unless agreed to by majority votes of members in secret ballots or by any other democratically accepted method by members present at the National Delegates Conference of the Union. A. Any member shall have the right to initiate court action at his or her own expense in connection with any breach of the provisions of the Constitution, provided that an appeal to the higher organs has been made within 30 days and determined before such an action could be initiated. B. Any grievance arising from the decision of the NEC or conduct of National Delegates Conference should be reported to the NEC for reconsideration before the aggrieved person can initiate any further action. Strict compliance to this provision shall be observed by all members of the Union. C. Any member that fails to comply with Rule 5, Sub 5, A and B before initiating any court action shall be expelled. Unquote. Having perused the entirety of the processes filed by the claimants, it is obvious that the claimants have not disclosed in any of their processes their compliance with the above rules, which govern them as members of NOLGE. It is tried that remedies provided for in statute must be exhausted by an aggrieved party before he approaches the court to institute an action. The courts have further held that aim of statutory preconditions for commencement of actions is to provide an opportunity for settlement out of court. The intendment is to give the person contemplating court action opportunity to give the matter a second thought before embarking on avoidable litigation. Unless the conditions precedent to the institution of an action are complied with, the party initiating the action cannot ignite the jurisdiction of the court to hear and determine the dispute. In such a case, the matter has to be struck out. Where a statute provides for dispute resolution before resort to litigation, failure to exhaust those remedies is a bar to litigation and puts the jurisdiction of the court on hold. See Fadairo and others versus Nasu and another, 2024 LPLR 62868 Court of Appeal, Mining Cadastral Office and UIG Petroleum and Transport Investment Limited and another, 2018 LPLR 46046 Court of Appeal, referring in Senator Ahmed Ebute and Abuja Electricity, Attorney General of Kwara State and another versus Alhaji Saka Adeyemo, 2017, All Federation Weekly Law Report, Part 868 at 610. From the foregoing, the claimants in the instant case have not exhausted the internal remedies put in place by the defendant before approaching this court in seeking redress. Hence, the action is premature and cannot activate the jurisdiction of this court, and I so hold.
As the court pleases.
Regarding issue 2 of the applicant, I have again referred to the claimant's processes vis-a-vis Rule 3 of the rules of this court, with this generally with forms and commencement of action. The claimants have failed to fully comply with the provisions of the rules of the court in filing their processes. The claimant's action against the defendant is by way of originating summons application, and Order 3, Rule 17 of the rules of this court prescribes the form of commencement of such an action, particularly regarding the processes which are to accompany the application. The claimants are thus well guided as the rules of this court makes it mandatory regarding the documents to accompany the originating summons of the claimant's applicants. It is right law that the rules of court are not made for the fun of it, but must be followed and adhered to. They must prima facie be obeyed. If there has been a non-compliance with the rules and it is not explained, then unless it is of minimal kind, no indulgence of the court can be granted. See Chief Omukakalu versus Chief Victor Odili and others, 1992, LPLR 1653 Supreme Court. This court has equally observed that the first claimant in this suit has withdrawn his participation in the suit, sequent to his mandatory retirement from the unified service of the local government of Zamfara State. This was another line of arguments of defendants in their issue 2, wherein they have challenged the participation of the first claimant in this suit to the effect that he has no local standard, having ceased to be a member of NOLGE by his retirement from the local government service. The first claimant has admitted to this fact via this letter dated 29 November 2024 and copied to this court. Be that as it may, from the face of the originating summons application and in view of the first claimant's withdrawal from this action, it is clear that the first claimant has ceased to be a party in this suit. Hence, this suit as it stands is incompetent before the court, and I so hold. See Order 13 of the rules of this court and the case of Oyeyemi and Oweye, 2017, 12 Nigeria Weekly Law Report, Part 1580, page 364 at 416, paragraph C to D. Against the above backdrop, I find merit in the preliminary objection of the defendant applicant dated 23rd August 2024, filed 26 August 2024. Also, the two issues are resolved in favor of the defendant applicant. Consequently, the originating summons application of the claimant dated on 5-15 August 2024 is hereby struck out. No order awarded as to costs. Ruling is hereby entered.
The court pleases. Most obliged, my lord.
You're welcome.
Most obliged, my lord. We are grateful.
You're welcome, counsel. All right. Yes, Abbas, you can call the next case.
NICN/SK/04/2024 between Godwin Osadi and Medum Pharmaceutical Limited. The case is for mention, my lord.
All right. Any counsel, please. Any of the parties in court, Abbas?
No, my lord.
How about counsel? Any counsel in court?
No, my lord.
Were they served with hearing notice for today? Are they aware of today's date? Because this matter ought to have come up on 17th of February, but due to the network failure, we couldn't sit. The court could not sit.
Yes, my lord.
So maybe for this reason, I would have to allow an adjournment in the interest of justice. So we allow another adjournment. Because I'm not sure if you serve them with hearing notice. Yes,
I send them.
Sorry?
I send them an SMS for today's hearing. Yes, my lord.
Did they respond?
No, my lord.
So there was no response from their end?
Yes, my lord.
Yes, when you send them the SMS, they didn't respond. So how do I know if they actually got your SMS message?
They didn't acknowledge the SMS, my lord.
All right. So in the interest of justice, I will allow another date. Yes, give me the diary. Let's see the dates for Sokoto.
Okay, my lord.
Where's my own diary? Oh, okay. But yes, collect it from her. Collect it. Officer, collect my diary from the secretary, please. So Abbas, you fix it for 18th of March.
Okay, my lord.
So the case is adjourned to 18th March 2025 for mention.
Escort, please, my lord.
So I repeat again, case adjourned to 18th March 2025 for mention. Hearing notice
Escort,
shall be served on all parties.
okay, my lord.
Call the next one.
Okay, NICN/SK/07/2024 between Farouk Nuhu Kuku versus Sokoto and 3 others. The case is for mention, my lord.
Any of the parties in court?
No,
Yes,
my
my
lord.
lord, counsel for the claimant.
I said parties, not counsel.
The parties are not in court, my lord.
All right. So appearance of counsel, please.
Wait, please, my lord. My name
Yes.
is A. Tahiru. I
Sorry?
appear for the claimant. My name is
What's
A.
the name?
Tahiru.
A.
Tahiru.
Okay, Dahiru. Dahiru, yes.
For the claimant, my lord.
All right. How about defendant's counsel?
May it please my noble lords?
Yes.
RT Mustafa, my lord.
RT.
RT Mustafa. RT.
R for radio.
R for rich.
Okay, whether rich
Yes,
or
my
radio,
lord.
yes.
R for rich.
RT.
RT Mustafa.
Okay, Mustafa.
Yes,
Yes.
my lord.
You are
I
for the
appear for the
defendant.
defendants, my lord.
All right, thank you.
Yes, all the defendants. I
All
appear
right,
with my friends, my lord.
Yes.
DD, Gang.
Spell the last name.
DD, Gang is spelled DYANG.
Yes.
GYANG. Gang.
All right. Yes, counsel, claimant's counsel, Dahiru.
Yes, my lord. The matter is for mention, my lord, and issues has been joined, my lord. The defendants filed a statement of defense on the 2nd day of December 2024, my lord.
Yes. So if you have joint issues, yes, defendant counsel.
And we also filed a statement of defense on the 2nd December 2024.
Yes, so since you have joint issues, we give you a date for definite hearing.
As the court
As the
pleases.
court pleases.
Let's have the diary, please. Hmm? What's the date for Sokoto there? How many hearings do we have? March what? March 18th. What's the next date? We have already 2 matters for trial. What's the next date for Sokoto? We have a clean date for them. Well, you can fix it for that either March 18 or except we are going to take it for. Okay, they are for Sokoto matters. Okay, 18th March. 18th March.
18th March, my lord, is convenient.
Hold on, counsel, hold on. That's not for Sokoto, so we can maintain the same. We are not taking that. We can maintain Friday. That's 21st March. 21st March.
It's convenient, my lord.
All right. Yes, Dahiru.
It's convenient.
Yes, my lord.
All right. Yes, counsel, I think you should be available if the network by 9. Can we make it 9? Because when when we have a sitting lately, it's usually, we have network issues. Do we put 9 or 10 o'clock?
9, my lord. 9 will be
very, very convenient. 9 is
yes,
convenient, my lord.
Yes. Mustafa, we are online. So we
Yes, my lord.
further adjourned 21st day of March.
Yes, my lord.
2025 for definite hearing, and that shall be by 9 o'clock, and the matter will be taken virtual.
As the court pleases.
Thank you, my lord. We are most grateful.
You're welcome. So, claimant counsel, prepare your witness.
Okay, my lord.
All right. So that will be all regarding this matter. The case is adjourned accordingly.
As the court
pleases. Thank you, my
lord.
Okay.
Sokoto, call the next case.
Yes, my lord. We have another case.
Yes.
NICN/SK/02/2022 between Bashar Balawala versus Kaduna Electricity Distribution Company PLC. The case is for adoption, my lord.
Parties absent.
My lord,
yes, my lord.
claimant is present.
The claimant is where?
Is present, my lord.
Okay, the claimant.
The claimant is Bashir Bala.
Yes, my lord.
Where is he? Is he in court in Sokoto?
No, my lord, he's not in court. He's online.
I can't see him. So if you are not for this matter, please kindly exit for now so that I can see those that are in this matter. You can shut down your... Appear, where is the claimant?
My lord, the claimant is online.
Can the claimant respond if he's online? If he can't respond, then he's not online. Not counsel, I said claimant.
I am here, ma'am.
So claimant present.
Yes, my lord.
Defendant absent. Counsel, announce your appearance, please.
May it please the court.
Yes.
My lord, my name is Usman Abbatukur.
Usman?
Abbatukur is my name. Usman Abbatukur.
Okay, yes.
My humble appearance is for the claimant.
How about the defendant counsel?
Respectfully, my noble lord.
Yes, okay.
Yusuf Muhammad is my name.
Yusuf?
Muhammad, my lord.
Yes.
My lord, my appearance is for the defendants.
Yes, sir, counsel.
Yes, my lord, the matter come up today for adoption of final written addresses.
Yes, sir, counsel.
The matter come up today for adoption of final written addresses and subject to the court convenience, we are ready.
Yes, sir, Yusuf.
We are equally ready, my lord. However,
yes,
we have a pending application filed on the 8th day of August 2024.
Tukur, have you been served with that application?
Well, we have not been served.
Okay, he said he has not been served, so would you be opposed to that application?
My lord,
yes, he said he has not been served. Mohammed is entitled to be served.
My lord, I doubt if they were not served because it was served on them together with our reply and they respond to our reply, my lord.
Okay, let's confirm from the court registrar over there. Abbas.
Yes, my lord.
Please kindly confirm service of the final written address of the defendant on the claimant. In this case, the final written address of the defendant, kindly confirm to us if you have the proof of service so that we can make progress.
My lord, I see the acknowledgement of a defendant final written address to the claimant written address.
The acknowledgement is there.
In defendant's reply to the claimant written address, my lord. They were served.
So there is proof of service.
Yes, my
see them, my lord.
All right, thank you. Once you can confirm to me over there, that suffices.
Yes, please.
Abbas.
Yes, my lord.
Yes, the particular process I want you to confirm is the motion filed. I think that's what counsel said. The motion, not the final, the motion. He said he filed it along. So is that motion to regularize? That's the claimant's motion. I think that's the claimant that filed that. Is that, sorry, defendant?
Yes.
Is that the defendant's motion to regularize reply?
Okay, my lord.
Yes, so is that application I want you to confirm if
Okay, my lord.
that's the motion the defendant filed. Just confirm if there's proof of service.
Yes, my lord.
There's proof of service.
Yes, my lord.
Okay.
See it, my lord.
All right, thank you.
Received by one Loki Benjamin, the secretary,
Right.
15th
Okay.
August.
15th August.
Yes, my lord.
20 what? 24.
Yes, my lord.
Yes, Tuku, but not Tuku.
Yes, my lord,
sorry.
I have seen the application filed by the counsel to the defendant, and we are not upholding the application.
All right, okay.
The harmless application, your lordship.
Yusuf, proceed with that application and move in terms.
Court basis. My lord, the application filed on the 8th day of August 2024.
Yes.
My lord, the application is praying for an order extending time to the defendants to file his reply to the claimant's final written address.
Yes.
My lord, prayer 2 is deeming the separate copy of the reply filed as having properly filed and served on the claimants.
Yeah. Counsel, can you conclude your application, please, or you're moving the application? Abbas. Just call them. I don't know. I think once we don't have a network, we just stop.
Yes, my lord.
Counsel, online.
Yes, my lord, we move in terms of the motion paper and urge my lord to grant the prayers the relief sought by the application. We are most grateful.
So others are all granted as prayed in the application of the defendant applicant, dated December 2024. Yes, Claimants Council, you have another application. Yes, Tuku.
Yes, my lord. My lord, we have another.
Yes, my lord. My lord, we have another application.
Yes.
We have filed and served the defendant.
Yes, Yusuf, can you confirm that? Yusuf, can you confirm if you have been served with that application?
Completely.
Defendant Counsel, have you been served?
My lord. My lord.
Have you?
Yes, I am muted by the admin. That's
You
why I
muted?
cannot. Yes.
Okay. Have you
My lord,
been
we
served?
said if the application is to regularize.
Yes.
My lord, we have no objection to that.
Yes, Tuku, move in
Yes,
terms of the application, move in terms.
At the court please, my lord. My lord, the defendant, having not opposing our humble application,
yes,
dated the 9th day of September 2024,
yes,
and filed on the 11th day of September 2024, my lord.
yes.
We move in terms and urge your lordship to grant our application as prayed.
Equally, orders are granted as prayed in the claimant's application. That's dated 9th day of September 2024 and filed 11th September 2024.
Of course, please. We are grateful, my lord.
Yes, Counsel.
My lord, the claimant final written address.
Yes.
Was dated the 31st day of June 2024.
Yes.
And filed on the 24th day of June 2024.
So it was filed the same date?
No, my lord, it was dated 21st, 21, and filed on the 24th.
Okay. Yes, Counsel.
We adopt them as our legal submissions.
Yes.
In urging this honorable court
yes,
to enter judgment in favor of the claimant.
Yes, Counsel.
And grant all the relief sought by the claimant, my lord.
Yes, Counsel.
Yes, my lord. My lord, often been served with the dependent final written address.
Yes.
The claimant filed a reply on point of law to the defendant final written address.
Yes.
Dated the 9th day of September 2024.
Yes.
And filed on 11th day of September 2024, my lord.
Yes, Counsel.
My lord, we adopt same as our legal submissions.
Yes.
In urging this honorable court
Yes.
to enter judgment in favor of the claimant against the defendant. Enter judgment in favor of the claimant against the defendant.
Yes, all right. Would that be all?
Not obliged, your lordship. Thank you, ma.
Yes, is that Yusuf? It's
My
Yusuf.
lord, on our own part, on behalf of the defendant,
yes.
My lord, we filed a dependent reply to the claimant final address.
Yes.
On the 7th day of August 2024.
On 7th day of August.
Yes, my lord.
Yes.
My lord, we adopt the said reply to the claimant final written address.
Yes, Counsel.
My lord, as our legal submission, in urging your lordship to dismiss the suit.
Will that be all?
My lord, with your permission, I will just like to adumbrate on one issue, my lord. With your permission.
Where is the defendant's final written address? It should be this. It should be this. Yes, Counsel.
Yes, your lordship. Your lordship, the dependents at paragraphs 22, 23.
Yes.
And 24, 25, and 26 of their statement of defense.
Yes.
Filed on the 7th July 2023.
Yes.
My Lord, I've asked in summary that the decision of the committee dismissing the claimant from its service is based on the fact that the dependent fails to appear before the management disciplinary committee established or constituted by the first dependent.
Is it the defendant that failed to appear or claimant?
No, the claimant, Your Lordship, the claimant.
So start all over again. You have referred
Yes,
me to those paragraphs, yes.
Yes,
You
Your
have
Lordship.
you are
We are
valid.
to paragraphs 22,
Yes.
23,
Yes.
24,
Yes.
25,
Yes.
and 26 of the joint dependent statement of defense.
Yes. Yes.
Yes, Your Lordship. In those paragraphs, the defendants have asked that the decision of management disciplinary committee established by the defendant,
yes,
to dismiss the claimant is based on the fact that the claimant failed to appear before the management disciplinary committee to defend himself.
Yes.
Yes, my lord. My lord, during cross-examination,
yes,
the claimant identified and admitted Exhibit C13.
Yes.
That he is the author. He was the one who authored Exhibit C13.
Yes.
Which, my lord, in the Exhibit C13, he communicated to the first defendant that they should proceed with the proceedings of the committee and pass their decision through the means they used to communicate with him, my lord.
Yes.
My lord, the law is tried that evidence elicited during cross-examination
yes,
which support the argument contained in the pleading of a party
yes, counsel.
my lord, is as good as the evidence called by that party, my lord.
Yes.
And my lord, the answers and the Exhibit C13 had proved the allegation contained in paragraphs 22 to 25 of the defendant's statement of defense.
Yes, counsel.
So we urge your lordship to so hold.
Yes.
That the defendant did not in any way breach the claimant's right to fair hearing, my lord.
Yes, counsel.
My lord, taking into consideration Exhibit C10,
yes,
C11,
yes,
and C11, C12, and C13, my lord.
all right.
We are most grateful, my lord. We urge my lord to dismiss the claim for lacking in merit. We are most grateful, my lord.
We'll give you a date. Will that be all?
Yes, your lordship.
All right.
Yes.
So we'll give you a date for judgment. So you may check your diaries for 10th of April.
As
As
court
court
please.
pleases.
Yes, my lord.
10th of
My lord.
Yes, Chuku. Is that Chuku?
Yeah, it's Muhammad, my lord.
Sorry, Mohammed. Yes.
Yes, my lord. My lord, before I take my leave, my lord, I deem it fit to raise a point of correction to the registrar of this honorable court, my lord.
Okay.
My lord, I heard him repeatedly saying, okay, my lord, which I perceive as not properly language to address the court. My lord, he may call it either as court pleases or yes, my lord. Yes.
Thank you,
So
Counsel, for that observation. Thank you so much.
Thank you, your lordship. We are grateful.
I hope, Abbas, you are there.
Yes, my lord, I'm there.
Okay, so I hope you are well guided. Yes, so you
Yes,
should be familiar with the language of the court.
As court pleases.
Yes, my
All right. Thank you, Counsel.
Thank you, my lord.
Thank you, my lord.
All right. Hold on.
Thank you,
Let's
your lordship.
confirm. Yes, with this should be two. Yes, we are aware. We put it. So 10th of April, will that be okay for both counsel?
My lord, is okay. Is convenient in our part.
Okay.
And on
so
the part of the claimant, 10th of April is convenient, your lordship.
Okay, so we'll say what time can we, let's see the diary, because we have one for Abuja judgment. Let me see. So we can give them 11 o'clock. Well, Counsel, can we take the judgment for that case? Is it for Abuja?
Yes, ma'am.
Is it virtual? The first one?
Yes.
Okay, so 9, 10, 11. Yes. Can we take it for 11 o'clock?
As court pleases.
My lord is convenient 11.
Okay.
Thank you, my lord.
You're welcome.
Thank you.
Case is further adjourned to 10th of April 2025 for judgment, and this shall be taken by 11 o'clock, and the same manner it will be done virtually.
As court pleases.
As court pleases, we are grateful, my lord.
Thank you.
Pass, can you call the next case, please?
That's also
Yes, Abbas, are you there?
Yes, my lord, I'm there.
Call the next case.
My lord, that's all for Sokoto.
Are you sure?
Yes,
That's
my lord.
not. We have 3 more matters for Sokoto here, even 4. Do we have any parties online or council for Sokoto?
Yes, my lord. Yes, my lord.
I think, do we have SKO1 2022? Musa Salihu Sakaba and First City Monument Bank. Do we have anyone online? So if there's none, on this, I don't know if I can give them here an issue hearing notice. I don't know how I think when we were meant to have taken this matter, the court did not sit, and probably the Sokoto registrar was not aware of this date.
Yes, my lord.
So I would give you a date so that you issue hearing notice to them in respect of this. Let's see the next date for that is convenient for this, meant for hearing of application and definite hearing.
As court pleases, my lord.
SK. So Abbas, you note it is SK01 2022.
Escort, please, my lord.
Saliu Sakaba and First City Monument Bank. What date? Can you put it for 21st of March? 21st March.
My lord.
They are not aware. That's what he said. So Abbas.
Yes, my lord.
You noted the date, 21st March.
21st March.
Yes, 21. So Abbas case is further adjourned to 21st March 2025 for hearing of application and definite hearing. Hearing notice shall be served on all parties.
What is my
So you say you don't have any other matter for Sokoto, but we have matters here, so I'll keep calling them. Abbas, I hope you are still with me.
I'm with you, my lord.
Okay, we have SK, another one, SK. Can you pick this, please? SK05 2023, Abubakar Mohammed versus First Bank, Nigeria. Do we have anyone online, any party or council?
No, my lord.
So you sure no hearing notice served as well? So there was no hearing because the last date was 21st November. I don't know if hearing notice was served. Can we give them the same date? Let me see the diary. Or you open another date. How many cases there for trials? Yes, Abbas, you have 21st. We can take it for 21st.
What is my lord?
21st of March.
At court, please, my lord.
The hearing notice shall be served on all parties. Case adjourned to 21st March 2025 for definite hearing.
At court, please, my lord.
Next is SKO2 2024. Do we have any counsel online? Fahad
No, my lord.
Musa, Medicine Sans Frontiers.
My lord, we don't have counsel, my lord.
Okay, no counsel. So the same thing. We have to open another date for this. Can you check another date? Because we have already 2 matters for trials there. Yes, for Sokoto, open another clean date. 11 April. Okay. Did we fix any matter for that day? No. What about the Easter?
No, Easter is 1820.
Resumption.
Resumption is no, not.
Did I fix any date before this?
Because we have something.
We have cases. Yes, Abbas, 11th of April.
At court, please, my lord.
That's for definite hearing.
As court please, my lord.
Hearing notice shall be served on all parties.
As court please, my lord.
And lastly, I have SKO 6/2024, Tani Suleiman and others versus Kaduna Electricity Distribution Company. Do we have any counsel?
Yes, my lord.
All right. So Abbas, I hope you are you are online.
Yes, my lord, I'm online.
Any parties there online or in court?
Yes,
No, my lord.
The defendant is represented.
Okay, claimant is absent.
Yes, claimant is absent. Defendant represented by Daniel Abu, head of legal.
Appearance, please.
With profound humility, my lord, I am Valentine Ajibo. Valentine Ajibo.
Ajibo.
Yes, my lord. Yes, Ajibo, Ajibo.
Yes.
I announce my humble appearance for the defendant.
How about the claimant's counsel?
Probably he was not notified because this matter was supposed to come up on the 11th of February.
Yes. Exactly, the court did not sit, yes.
Yes. So I'm surprised he's not here. I believe probably he was not notified, probably.
Even the court registrar in Sokoto says not aware that the matters are coming up today. So probably it was not communicated to from here. I don't know. Yes, counsel.
Yes, my lord, the matter is supposed to come up today for hearing.
Yes.
We have a pending application, my lord.
I'm not going to take any application since we are not sure if the claimant's counsel was served with hearing notice for today.
Yes, my lord.
So
yes, my lord.
in the interest of justice, I will not take any application. I would rather have it adjourned and so that hearing notice will be duly served on the claimant's counsel.
As court pleases.
So counsel will give you a very short date so that you can we'll suggest the available dates to you and ensure that the hearing notice. Abbas, I hope you are there.
My lord, I'm there. I'm with you, my lord.
Give me the diary. Let's see what dates that we have. 2 dates for Sokoto. This one is for definite hearing as well. Is that the closest date?
We have
okay.
21st of March. We have 3.
Oh, counsel, we have 11th of April.
11th of April. Sorry, my lord, I'm trying to confirm from my diary.
Please, look.
11th of April is convenient, my lord.
So case is further adjourned to 11th April 2025 for definite hearing.
Ascot pleases.
The hearing notice shall be issued and served on the claimant counsel.
Ascot pleases.
Ascot pleases. We are most grateful, my lord.
All right. So Abbas, I think that should be all from our end.
My lord, that's all for Sokoto, my lord.
All right. So you make sure that hearing notices are served accordingly.
Ascot pleases.
All right. So that will be all. Thank you.
Thank you.
Remember.